Hello. Can anyone hear me? Is there anyone here? Oh, hello. Hi, SV5679. Um, this is working. It's been a challenging day to get here, guys. uh, so it was at first I got five when I was supposed to go on. Um, we had a I had a bit of a problem in that like Streamlabs was not working for me for some reason. And so I tried to fix it and spent like an hour or so until um, you know, community hero, the silly Sirius, came to my rescue and helped me to fix this. Um, and told me essentially what was going on. And so apparently, what was going on is that um, my stream key was missing, so I needed to verify a phone number for this to work. And like it should be more um easy to figure out, but yeah, what can I do? I am an old millennial of 38 years old, and the last time I was any good with any app was like MSN Messenger. So, um, anyway, it's been a challenge. I just want to know if everyone can hear me right. Like, is everyone um like I think there's like 7 viewers right now. Can you hear me? Is the stream working? Yes, awesome. Yes, we can. Yes, yes, awesome. Okay. Um, oh, the City Series. Hey, how are you? Thank you so much for your help. Like, you're the hero of the day. I don't know how we would have managed without you. Um, okay, so we're 2 hours late, so I acknowledge that everyone like probably had plans and scheduled this for five. So hopefully this won't be too much of a problem for you guys. Um, but let's try and catch up. Okay. Um, so a little bit of like housekeeping from the start. I now have a new fancy Ethernet cable, which I have right here, and it allows me to stream on my PS5. If you noticed, if you were here last Wednesday and you saw me trying to play The Last of Us, it was sort of a massive failure because um, my apparently my PlayStation is like in a corner, too far away from the router, and so it doesn't get enough internet over the Wi-Fi. I'm learning so much about computers that it is really funny. Um, and it's funny because in the 90s I was supposed to be good with computers. Like people asked me for help when they had problems with their computers in the 90s. Now I've lost my power. And so now on Wednesday, I think I scheduled it. Yeah, it's on Wednesday at 4. Will be streaming The Last of Us, talking about international law, now guaranteed to work. Actually, if you go on the account for now, there's like the test I run is there for now. I'll delete it eventually. Um, but yeah, you can see me playing in like relaxed mode. That's not my actual skill level. Um, Okay, so we were supposed to talk about self-defense today, and as always, like if anyone has a particular question, like a burning question that you guys have right now, just put it on the chat. I'll answer it as best as I can. It's six of us, so it should be working just fine. Seven now, six again. So it shouldn't be that difficult to like answer questions. The general. Oh, I just noticed our dinery is a first-time chatter, so welcome to the stream. Um, Otherwise, like what I'll do is I'll just start talking about like my notes. I like to approach this as if it were a class, right? So let's do it that way. Um, so I think it's important, like when we're starting, and again, if you have any questions, just put it in the chat. Um, from the beginning, it is important to talk about self-defense. Um, I guess in isolation from everything that's going on right now in the Middle East, in Israel and Palestine, and then once we understand how it works, once we understand uh, the rules, then we can tie it up to what's going on over there. I just want to avoid, um, you know, just connecting the idea of, oh, everything is about Palestine and Israel. No, this is about international law and how international law works. And when you apply those rules, or at least the interpretations that I have of those rules, to the Israel-Palestine situation, you get a specific result. Because it is a very common accusation that, oh, you're just holding Israel to a separate, different standard. And I want to make it very clear that that's not what I'm doing. What I want to do is for you guys to understand what is self-defense. That's why the title is there. Um, and yeah, hopefully that helps. So let me just start by telling you what is self-defense, um, how to regulate the way that states use force in international law. Okay, when can a state go to war against another state? When can a state deploy military force in another territory? You need to understand that one very important principle of international relations is non interference, peaceful solution of disputes. You are not supposed to forcefully enter someone else's territory, so another state's territory, and do in it whatever you want. There's a long history that we can talk about later about where that comes from, because it wasn't always the case. If you've heard the term gunboat diplomacy, you sort of know where what I'm talking about. The idea that you just send your ships and you get another state to do whatever you want. That's not how international law is supposed to work right now. Even if it sometimes is. Um, and so the premise right now that we have is you cannot use force in someone else's territory without meeting specific rules, right? And those rules are contained in general principles of international law and in the UN Charter. Okay, so let's go through them to understand what we're talking about when we're talking about self-defense. So the first thing, the first principle would be consent, meaning that if a state says, hey, you can come into my country and use force here, you can. Like, if you have consent of the state involved, then you can use force in its territory. This is usually what, France is doing in Africa, like for example in Mali and other countries, where it's sending its troops to help that country fight a threat that it says it has, right? So, if it's consensual use of force in the territory of another state, then we don't have to worry about whether, some of the exceptions to non-consensual use of force applies. Unilateral use of force applies because obviously you have permission. Now it can get tricky and complicated, and we can talk about that later, because like whose consent? If the country is in civil war, for example, can any side of the civil war request help from another person? Like, this is very vanguard, cutting edge stuff. It's not entirely clear who's right and who's wrong. International law is in flux in that area. The International Law Association is working on this at the moment to try and figure out if we can build consensus on it. But generally, yeah, if you have consent, you can use force in someone else's territory because you have their permission. Um, we can complicate this further down the line in the video. The other two exceptions to use of force is, when can you use force when you don't have consent, when you don't have the permission of the state involved, right? And it's very fundamental, very basic. Um, in the UN Charter, you can only use self-defense without consent unilaterally in two circumstances. Number one, when the UN Security Council says so. So the 15 members of the Security Council say that you can actually go to war with someone. This is like what happened in Kuwait when Kuwait was invaded by Iraq. So um, a global coalition was authorized to go into Iraq and stop the invasion, the conquering of Kuwait. And so when you have Security Council authorization, you can use force. Okay. Um, the and the second one, the second exception to when you can use force without consent, that's self-defense. So you see, when I still don't know, I tried, I really tried to like put like images and dialogues like floating here, like talk show style, but I'm not there yet. If you know how to help me do that, please do, because it would be very helpful to like put, like an infographic here floating next to my head. I have no idea how to do that yet. I'm learning though. I already learned how to generate a stream key. So like yesterday I did not know what a stream key was. But so just to reorganize, you have either consent or Security Council authorization, or you act in self-defense. Those are the three only instances where you can act in someone else's territory. And that's when it gets complicated. Um, because just like you can say, okay, whose consent? If there's a civil war, what if there's a civil war? Self-defense is also a term of art. And it is usually mistaken, it is usually spoken of as a very colloquial term, as like anything that a state does counts as self-defense, and that is just not true. And I'll differentiate self-defense from other theories, other concepts in a bit. But let's just say that self-defense is what happens when a state protects itself against an imminent or an ongoing armed attack, one of those technical terms, which is basically using force to a specific degree. Um, like if a Mexican soldier slaps a U.S. soldier in the border, that's not an armed attack, right? But if there's like a military movement of troops with the aim of invading another country, um, like let's say the Blitzkrieg during World War II, like Germany is sending tanks to Poland with the intention of attacking Poland, then Poland can respond in self-defense and use force against Germany, not triggering any prohibition on the use of force. Um, because we understand in the UN Charter that war is not how we want to solve differences in the world. The UN Charter has essentially banned um, use of force as a mechanism to resolve controversies. Right? I'll get to your questions in a second. I see that they're popping up more and more. I just want to set the groundwork up first. And so you have this it's armed, an imminent or an ongoing armed attack, and you respond in self-defense. That's allowed. It's allowed to the degree that the use of force that you're deploying is proportionate to the threat. So, for example, if I don't know, someone is sending a little battalion of ground troops, and in response you nuke the country's capital, that might be disproportionate. It is necessary in that only the use of force will dissuade this threat. Um, and so, like, when you have a use of force that is proportionate and necessary to repel an ongoing armed attack, that is legal. But that means that self-defense needs to be differentiated from a policy of reprisals. What is a policy of reprisal? A policy of reprisal is you strike me, therefore I strike you. If your armed attack concluded and then you use force, that's a reprisal. It's no longer ongoing or imminent, it's concluded. So that would be a reprisal. And you can see how the line is blurry there, right? But okay, but that is the general gist. We'll go into more detail as the questions, come through. Um, but the general idea is you can only use force in the territory of another state if you have their consent, if you have Security Council authorization, or if you're acting in self-defense, meaning that there is an ongoing or imminent armed attack. And we can problematize that further. For now, let me see the questions. Okay, so Silly Series says the UNSC approval. Is UNSC approval the same as R2P, or is that just for internal issues? Okay, so we're getting straight into the thick of it. So R2P stands for responsibility to protect. Uh, Before I explain what responsibility to protect is, I need to go back a little bit to the days of the late 90s, when I was struggling through high school. It was a dark time. It was not a nice era. And so, but it was a time when people thought that I mean, Francis Fukuyama said it outright, right? History had ended. Like the good guys had won, the bad guys had lost, and it was going to be like perfect now because everyone was going to be a liberal democracy, and human rights and international law were going to fix the world, right? So that's why when you see, like, I don't know if you're any movie buffs here, but look into sci-fi movies from the 90s, particularly Independence Day. It's this moment, this zeitgeist where we thought that the world was going to get fixed, everyone was going to unite. Like there's a famous scene in Independence Day where a Palestinian and an Israeli shake hands so that they can go destroy aliens together because world peace was right there, imminent. And like the 4th of July will no longer be known as an American holiday; it'll be you know a global holiday because it's our Independence Day and all that, right? So it's a specific zeitgeist where international law was going to solve everything. And then 1994 comes, and there's Rwanda, there's a genocide, and no one knows what to do because like the world failed. Right, Romeo Dallaire writes this "Shaking Hands with the Devil," this book on how the world failed Rwanda, and that's not possible because we won the Cold War. So the world is fixed. So let's fix it through international law, and this is when states started proposing um, a new fourth exception to the prohibition on the use of force. So consent, Security Council authorization, self-defense, or humanitarian intervention. Humanitarian intervention was the idea that in the case of Rwanda, you don't really need to wait for the Security Council to say, go in, because what if they don't? What if the structures of international law fail the Rwandans? So maybe you don't need to wait for that. So let's do humanitarian intervention instead. If there is a genocide, if there are war crimes, if there's crimes against humanity, you are allowed to attack, to protect the people that are being genocided, for example. Um, and this was people were very excited about this. In fact, I mean, I was in my first academic article somewhere in a Spanish-speaking law review by the students at University of San Marcos is about this. And when I read it back, I was actually very negative about it. More, I mean, for my current position, maybe not that negative as I am now, but I think it was not normal for people to be as cynical about this as me. I guess the seeds were there from the beginning. And so basically, my fear at the time was states don't act out of humanitarian interest because they're good and they want to save people. States, my personal belief is that states suck. All states suck. Last stream's hashtag was hashtag states weird again. Uh, this hashtag, this stream's hashtag would be hashtag states suck. And so if you give states a blank check to decide when there is a genocide, when is there a situation that requires the intervention of the international community, the expectation that they would be very, let's say, honest and good faith about it is kind of silly to me. If you give states a blank check and say, if you believe there's a genocide going on, you can go invade, right? Um, I mean, wasn't Iraq premised on humanitarian reasons as well? We need to save Iraqis from the horrors of Saddam Hussein. Do do any of us believe that the invasion of Iraq was premised on humanitarian and sincere humanitarian concerns? Um, so it is a very dangerous theory, a very dangerous philosophy to expand the use of force in this way. But in the 90s, it was all the rage. If you look at law review articles in the 90s, everyone was very excited about it. And there was this logic of like, yeah, it may be illegal, but it is legitimate. And then Iraq happened. And everyone was like, okay, yeah, maybe we got a little bit too excited. Between 1997 and between 1994, Rwanda and 2003, everyone was very excited, but then eventually said, okay, yeah, states will abuse this, right? Um, and so while there were very concrete let's say, projects to make this a thing, to make this the fourth exception, um, it didn't go very far because after Iraq, states sort of, particularly states in the global south, like Brazil or like Chile, Argentina, started to get worried that, yeah, this is just going to be an excuse to use force in whatever the world powers want. At the end of the day, international law is not neutral. Um, you, I mean, we can see it now where there's a huge humanitarian crisis going on in Palestine, and no one is talking in humanitarian intervention terms. And when Turkey does it, it's like an irresponsible thing to do, right? Um, so there's a double standard. So we need to be careful. Um, and so in 2005, when states got together to discuss humanitarian intervention, uh, in the 2005 UN World Outcome Document, that's the name of the document. I'll see if I can find it. Um, they Let me see. They concluded that to use humanitarian intervention, you would still need some sort of like Security Council authorization. To get to this point where the world said, okay, no, 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 let's not do this. There was an entire process of trying to turn humanitarian intervention into a working set of um, rules. That process from humanitarian intervention in the 90s, early 90s, to the World Outcome Document in 2005 is called R2P, the responsibility to protect. How did we get to that? Because in 2001, a group of scholars based in Canada started doing like a tour around the world, trying to convince states to regulate humanitarian intervention in a way that was like a little bit less free for all than people were scared. The people feared. And so they said, look, let's draw a set of ground rules. First of all, it's not the Wild West where you can just invade any country. Let's say that there is a primordial responsibility of every state to prevent um, atrocities. So every state needs to ratify the Genocide Convention, needs to comply with like human rights standards, and we agree that we will all pressure each other. All states will pressure each other to comply with these rules to prevent the uh, to prevent atrocities. And then if all of these fails, if all of if the pillars break down at the end of the day, then sure, then the last pillar would be, even if the Security Council says no, you can still intervene, and that would be legal. And everyone got very excited with R2P, but with Iraq, it was kind of like reined in. Said no, 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 we need to be aware that states will abuse this. So in 2005, R2P was sort of like approved by the world in the 2005 World Outcome Document, but it was approved with a very big caveat. It said you need Security Council approval first. So it's basically the process that changed the very excited Independence Day zeitgeist of the 90s, where we're going to fix the world with international law, to the point where everyone said, okay, we got carried away in the 90s. Now it's the early 2000s. It's the post 9/11 world. We recognize that states suck. Maybe we should have a few safeguards still. So instead of becoming the fourth authorized use of force rule, humanitarian intervention mutated into R2P sort of became a restatement of the Security Council authorization that I was talking about. So there are states that will argue that humanitarian intervention is legal, or that it should be legal. It's a very hard case because of the 2005 World Outcome Document that says, like, no, 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 you still need Security Council authorization. So it is not a fourth way of um, of authorizing force. It's just another expression of Security Council authorization that has more of a human rights packaging. It talks about prevention, it talks about non recognition of atrocities in other countries, but you still need UNSC approval, right? So let's say the United Kingdom. First of all, the first country that did this was Belgium. So when NATO started bombing Kosovo, I'm glad you find it interesting, silly serious. When the um, when NATO started bombing Kosovo in 1997, Serbia took the entirety of NATO to the ICJ, claiming that they were violating international law. And uh, Serbia requested provisional measures, very similar to what's going on with Israel and Palestine, Israel and South Africa. And in those provisional measures, they said, well, this use of force is clearly illegal because they don't have my consent, they don't have a Security Council authorization, and they don't have a reason of self-defense. I have not attacked NATO. So this humanitarian intervention is not valid, doesn't exist, and under international law, and so they're violating international law. Most states in NATO sort of like wobbled around these concepts, but Belgium presented, and I tweeted this not that long ago. I tweeted a thread on this if you want to find it, um, on highlighting Belgium's argument. Belgium responded to the ICJ in the provisional measures order hearing that look, humanitarian intervention is legal because first of all, it's upholding Jus Cogens, so peremptory norms, Jus Cogens obligations. So genocide is a Jus Cogens obligation. It's like a one of the main rules of international law. You cannot genocide. So if you intervene in a country to stop a genocide, then that cannot be illegal, said Belgium. And also, the UN Charter, the prohibition on the use of force, only bans force. If you read Article 2.4 of the UN Charter, it says like states will not use force in their international relations um, against the territorial integrity of another country um, or its political independence. And Belgium said, "I'm not trying to take over Serbian territory, and I'm not trying to make Serbia not independent. So this is legal. Of course, it's sort of silly. Oh, hey, accidental jurist, how are you? Nice of you to pop by. It's sort of silly to say that you're not affecting Serbia's territorial integrity by bombing Serbia, right? So um, that was a tricky argument to make. But Belgium made it. It was the first country to say humanitarian intervention is legal as an independent basis for the use of force. Um, and it's not the only one. In 2018, when uh, Assad used chemical weapons against Syrians during the Syrian civil war, there was this like problem with the United States. The United States had drawn a red line on the use of chemical weapons, and so the U.S., France, and the U.K. attacked Syrian um, chemical weapons caches. Thanks for following Boulevard of Dreams. And so um, the US and France were sort of saying, like, oh, this, our strike is not, let's say, against international. It's sort of like in the spirit of international law. But they didn't go as far as to say, we're complying with a legal obligation. The UK is different because the UK has an obligation under its domestic law that everything it does needs to be vetted by their international law, you know, affairs division. Which is a great thing to have. That's why everyone's demanding Keir Starmer to reveal whether that unit has determined that Israel is violating international law or not. And so, in order to go into Syria and destroy the chemical weapons with airstrikes, the International Law Division at the Foreign Office had to determine whether the strike was legal or not preemptively. And they did. They said that it was legal to attack, you know, Syrian chemical weapons. Um, they said that if there was a situation, a humanitarian crisis, and there was no other way in which you could um, prevent the atrocity, then there was a exceptional authorization under international law to go into another country. So that's it. Those are the two countries that accept that humanitarian intervention is part of international law. And as you know, international law changes. Well, I don't know if you know, but if you don't know, now you know. International law changes through practice. The more states do something, the likelier it is that that violation then becomes, legal. So right now, of course, two states is not enough, but it is still like something that they are arguing that it is legal. So far, to me at least, because of the fears I have that humanitarian intervention or R2P without Security Council authorization would be abused by states because hashtag states suck, um, then it's not enough to have two states that say, oh yeah, whenever we decide that there's an atrocity, we can intervene in that state or not. Uh, I would say that that's not enough, and therefore humanitarian intervention is not legal as we start. There is an excellent article. I'm going to see if I can find it by a friend of mine, Kevin Heller, on whether humanitarian intervention is legal or not. I'm going to paste it on the chat so that you can access it. It's a really good article. I really like it. Uh, there you go. You should give it a read. Um, Kevin is very good with these things. Okay, there it is. So, yeah, that's the very long answer to the silly serious question of whether R2P is the same as UNSC authorization, which means we've covered now humanitarian intervention, right? That's one more thing you guys know now. Just one person out there says, does self-defense apply to Hamas attack on October 7th? Oof, God, okay. You went straight to the mother load. I will touch upon that. Okay, I guarantee that I will. But let me set some of the basics first before we get there. Because as I explained in the beginning, I want to make sure that we understand that this is a um an explanation of international law that then we can apply to the Palestinian situation. Okay, so let's put a pin on it. We will definitely get to it. But wait 1 second. Still serious again. Also, question for later. Can you explain the relation between self-defense and preemptive strikes? Yes, that is also another interesting question to solve. So I said that there is a self-defense occurs. Self-defense is triggered when there is a imminent or ongoing attack. An ongoing attack is very easy. If you're being bombed, you can defend yourself from those bombs, right? Um, if there's an armed attack, you can defend yourself from that armed attack. The question is, when does that armed attack actually start? When can you say, do you need to wait for the bombs to drop on top of you for you to say, okay, now I can defend myself? And of course, the answer is no, but it's not an easy no because hashtag states suck. Um, they will abuse these determinations. So obviously, Poland could defend itself against the Nazi advance in 1939 because it was an imminent attack. But the definition of imminence changes depending on the state that claims it. Famously, for example, the United States argued that it could act in preemptive self defense against Iraq because there was an imminent threat that Iraq might use weapons of mass destruction that it did not have against the United States. So you can see how much they suck, right? States suck. And so um, in this scenario, the requirement of imminence itself, an aspect of whether force is necessary or not, was how can I uh, how can I say this watered down. That's the expression. Sorry, sometimes I forget the expressions. English is a complicated language, and so what is the definition of imminence? Like, Anglo-Saxon, U.S., UK lawyers like to use the example of the Caroline incident, which is an incident that I personally don't particularly think is very illustrative. I think it is um, a very self-contained scenario, a very self-contained incident that says little of what the practice of the wider world was at the time, because it's the UK and the US involved, and maybe Canada and nothing else. But it is this huge case for Anglo-American scholars that coincidentally I never studied it in law school. Like when I studied international law, I studied international relations, I studied international politics. I never studied this case. And then I arrived in the United States for my master's, and this was like the case that everyone talked about. And I was like, what is the Caroline? I don't know. Why don't I know? Like, I was already working with international law at that time. It was like really very much of a crisis for me not knowing what this Caroline thing was. And so the case of the Caroline is back when Canada was still under the control of the British Empire, and the United States was already independent. I think this is 1842. If someone can Google when the Caroline incident happened, I would appreciate it. It's 1842, I think. Um, and I 18, well, between 1835 and 1845. I don't think dates are that important in life. If someone can Google it, it'll be of a lot of help. But what was going on then was that there were Canadian rebels that were collaborating with Americans on the other side of a river. Um, and so they were using the Caroline, a ship, to go to the United States, get guns, and return to Canada. And so the British were not happy about this. So they wanted to destroy the Caroline, but the Caroline was already in US territory. So despite them being in US territory, the British crossed the border, boarded the Caroline, arrested the crew. I think one or two died in the operation. And then, um, what's the term? There's a naval term for this when you destroy a ship. They scuttled the ship by throwing it down I think it was the Niagara Falls or something, um, while burning. It was like a huge thing. And the United States argued that the UK had violated US neutrality, it had violated its rights as an independent state. Um, and the United Kingdom said, no, I didn't, because I had a right to defend myself from this attack that was coming from your territory. And the funny thing is that both the United States and the United Kingdom agreed that the standard for when the United Kingdom could attack a vessel in U.S. territory was if it was imminent. Right? There was no second of deliberation. It is imminent. There it is. It is a famous quote that says what imminence means, and there is essentially no time to deliberate. You need to strike, right? And so the United States said, "Of course you could wait. You didn't need to destroy the Caroline in my territory. You could have just waited until it crossed again and then destroyed it. Like, what's the problem?" And the UK was like, "No, because what if they got lost in the way? What if they didn't return? What if we lost them? Well, I mean, we don't know. It's the United States in the 1800s. It's sort of like wild frontier land. So no, we needed to destroy it." So they disagreed. The United States eventually made a big diplomatic fuss about it and secured an apology from the UK by saying, "Okay, we should have apologized for destroying the Caroline." But this standard, um, this like, let me read it to Caroline's standard. Uh, the idea of imminence in the Caroline standard became this like massive thing in international law in Anglo-American circles. So it says a self-defense claimant would have to show that the necessity of self-defense was, quote, instant, overwhelming, leaving no choice of means and no moment of deliberation, and that the British force, even supposing the necessity of the moment, authorized them to enter the territories of the United States at all, did nothing unreasonable or excessive. So this idea, instant, overwhelming, leaving no choice of means and no moment of deliberation, was the standard for when a state could act, when the United Kingdom could attack the Caroline in U.S. territory. And to me, that leaves it very clear that the standard was not met in the Caroline incident. But because it happened, and the UK only gave the US an apology, in the early 2000s, when scholars were looking for ways to justify an attack on Iraq, the Caroline incident became the standard. It was like, it's sort of like applied, in my opinion, wrong by its own text to the situation of Iraq and says, yeah, of course. Of course, this is like instant, overwhelming, leaving no choice of means and no moment of deliberation. They have nuclear weapons and they can attack us. And I think, of course, it's not imminent. Like, of course, it's not. Of course, you have a moment to deliberate. And at the time, in 2003, I was like 17. So, like, it didn't take a lot of international legal training to know that that was not the correct standard. But it is what enabled this idea that you don't need to wait until the attack is even imminent, because the British didn't. Right? So the concept of imminence sort of changed, and we called that the preemptive strike. So Iraq was a preemptive strike, or more actually, a preventive strike. You attack them to prevent them from doing something, which, in my opinion, is completely illegal, because no armed attack in, had started or was imminent or was underway, and I think we knew that at the time, but we can also figure that out today. We know that that wasn't the case. There were no weapons of mass destruction. So, um, so yeah, so I would argue that, what was the original question? Right, that the relation between self-defense and preemptive strike is, it would be self-defense when you actually meet the definition of imminence, when you actually have no other way to react. So, for example, when Iran sent a bunch of missiles at Israel, and I know there's a lot of like stuff going on in the middle, but let's just ignore all of that for a moment and just put ourselves in the situation where a state is sending a lot of missiles to another state. So Iran is sending a lot of missiles to Israel. There is nothing Israel can do other than blowing up those missiles, and or blowing up the launching platforms from from where those missiles are being sent. There's no other thing that Israel can do but that. It's either they do that or the missiles fall on Israel and destroy Tel Aviv. That's the kind of imminence that's required for self-defense. The Germans are marching through Belgium, and we need to stop them. That, or the Germans are marching through Poland, and Poland needs to stop. That's the level of imminence. We have twisted that level of imminence, that very high standard, that Caroline and others, cases set up, um, and watered it down to have a different concept of imminence, a concept of imminence where threats, like long-standing threats, can count as imminent. Iran's nuclear threat in 2003 was imminent, and so you had to attack. And of course, the United States argued in the case of Iraq that it did not even need to show that the threat was imminent, because it argued that it had Security Council authorization, which we can talk about that later. But I mean, long story short, I don't think they did. Um, but the discussion, the doctrinal discussion that was going on at the time was about what is this imminence that we're talking about. So that is the relationship between preemptive strike and self defense. Um, the idea that, yes, you don't need to wait for the attack to land. You can attack the German advance, but you cannot just preventively destroy someone because they might attack you. If they might attack you, then they're not really meeting the Caroline standard, no matter how much we want to reinterpret it in light of what the British did. What the British did is not an example of what was allowed by international law. It's an example of what wasn't allowed in international law. And it's very interesting how US commentators that defend the war in Iraq, for example, say that essentially the UK was right in destroying the Caroline, while US scholars from the 1800s did not. U.S. scholars from the 1800s were saying like, how dare the UK attack us like this? And now U.S. scholars are saying, well, yeah, they had a point. Why? Because back then the UK was a superpower, and superpowers deploy, their power extraterritorially, and the U.S. was a former colony with not the biggest army or anything like that. It wasn't a superpower; it was a regional power, and so it couldn't defend itself against the UK other than through diplomacy. Now the US is a superpower. So US scholars, when the US was not a superpower, were against what the UK did. US scholars, when the US is a superpower, are in favor of what the UK did. There you have it. That's the reality of international law, right? Um, High altitude Cherenkov says long-standing threats count as imminent, and laughing. Yeah, I don't think that's in any way justified by international law. We can talk more into how this has evolved over time. Right now, there's another standard that's called the unwilling or unable standard. Remind me of this in a bit, which is basically that. Like, if there is a threat, you can already attack, and that's just not how it works, right? Um, Moreover, in a time of like drone warfare, because self-defense can only authorize use of force in the territory of another state. That doesn't mean that the person you're killing was a lawful target under either humanitarian law or human rights law. Separate discussion that we can talk about it later as well. Um, so Edward SVM says so preemptive strikes okay under certain circumstances. Um, so I would rephrase that. Um, Attacks against imminent self-defense against imminent armed attacks are okay. If you want to call that preemptive strikes, then that would be legal. But if what you want to say is you have a right to attack them before they attack you, no, you don't. That's not how it works, or at least not how I think it works. Like, I'm sure that if you read John Yu, for example, he will probably say that that's how it works. The city series, is there an imminence requirement? Yeah, that's basically the Caroline standard that I already discussed. Um, so okay, has the iconoclast says, has there been any case of a global South country using this kind of intervention? Which kind of intervention? I'm assuming um, it must have been like humanitarian intervention, right? Um, so most global South states that I can think of have been reticent to adopt humanitarian intervention. Brazil and Argentina are even reticent to apply responsibility to protect. So um, there are states that have participated in like in the let me think about this. I don't think so. I can't think of any humanitarian intervention between global South states. But you know who might clarify that? The article by Kevin John Heller that I just posted in the chat. The answer might be there because he does a very thorough exploration of every single instance of humanitarian intervention. So he probably knows it better than me. I don't have it top of my head right now, I guess. Um, the the city series. What about actions of allies or supplies from allies? Thinking about how Ukraine can't use military materials from the U.S., etc., in Russian territory. Well, Ukraine can't use military materials not because of international law. It's because the U.S. requests that its weapons, like it's a condition of the sale. It's not international law at all. Um, Sending weapons. Um, so there's an idea in international law that we debate a lot about. It's called neutrality. Are states supposed to be neutral in the face of a war between two states? Right. So ideally, if two states go to war, the law of neutrality says that you maintain, you don't side with anyone. You maintain neutral status with both of them. And this um, is tested in the UN Charter system because the UN Charter says that you cannot use force in your international relations, right? Meaning that whenever there is a war, there's a high chance that one of the states used force illegally, right? Because unless there's an issue of consent that we're missing here, um, if a state says you are attacking me in my territory, one is acting in self-defense and one is acting as the aggressor, meaning that if they are the aggressor, other states are not supposed to help that state carry out their aggression. So can you really be neutral in today's world and declare yourself, I'm completely neutral with this state attacking this other state, when one of them has to be the aggressor? So there's a lot of discussion in international literature about whether the right of neutrality is still a thing. Um, and one thing that pops by in the literature a lot is this idea of qualified neutrality, which is usually talked about as an invention of World War II, when like the United States, for example, started sending weapons to the UK, um, while still being neutral, um, vis-a-vis the war in Europe. But really, as a Latin American, I have to say this is more of a Latin American contribution, because it's what Rui Barbosa, a Brazilian, very famous Brazilian representative and diplomat, said during World War One. During World War One, Rui Barbosa actually gave a lecture on why neutrality should not mean not standing in uh, on the side of like the small state, in this case, like Belgium being attacked, and how um, neutrality did not mean not sending weapons to help other states. Um, so I will claim that concept to for Latin American international law, but eventually, yeah, it became common parlance as qualified neutrality after World War II, and that's the idea under which states are sending weapons to Ukraine, saying I'm neutral, but I mean I don't need to be completely neutral in the face of aggression, so I will help them. And I guess like everyone is wary about World War III with Russia, and so the way the West is dealing with sending weapons to Russia, and Iran and North Korea sending weapons to Russia, is by sending little by little and with restrictions. But those restrictions are not imposed by international law. Nothing in international law prohibits Ukraine from using U.S. weapons in Russian territory. That's the U.S. not wanting to risk Russia's anger, and then Russia considering the United States a co-belligerent or something like that, and then Article 3 of NATO is triggered, and no one wants World War III, right? Um, I think uh, I think NATO is increasingly um, pushing back on these restrictions, like increasingly, like first it was like only defensive weapons, then it was any weapons except jets, then is all weapons but not in Russian territory. So the West is pushing and pushing and pushing, as the reality on the battleground reveals that Russia and Ukraine are basically on a deadlock, right? And so for Ukraine to succeed in defending against Russian aggression, they will need to be able to fight a war in more um, unrestricted ways. But yeah, but that's not a prohibition under international law. High altitude Cherenkov says it's almost like lawyers make arguments to serve the interest of their clients. Yeah, fair enough. Um, okay, so let's look at what's happened with self-defense since this debate, since the 90s with humanitarian intervention, and since the 2000s with preemptive self-defense. So right now, as we stand, you have you know now that to use force in another country, you need either consent or Security Council authorization, or to be acting in self-defense of a ongoing or imminent armed attack, and you know what that imminent standard is. You also know that states like the United States were pushing to relax that imminent standard so that it could apply to just less imminent threats, right? And more preemptive or preventive forms of use of force. How did that evolve? Because so for a long time, the United States struggled to find what was the legal rationale for its drone program, right? On two reasons. Reason number one, because like what I said, if you claim self-defense, even if you've watered down the necessity requirement, the immediacy requirement, you're still only authorizing use of force cross-border. You're not authorizing use of force in like the idea of who gets to be killed. Remember, well, maybe you remember, maybe you weren't born, I don't know, but remember the discussions about unlawful enemy combatants. That's where that came from because the United States needed to show that the people that they were targeting were unlawful enemy combatants that were targetable, right? They needed a category for that. That's outside of the scope of what we want to talk about today because then we would get very sidetracked. Um, but the other aspect of you know this this discussion um, is the idea of how do you justify the targeting of states all over the world in a global war against every single terrorist group that has ever populated the earth. And here's the problem: most of these groups, particularly as Al Qaeda began to splinter into like almost a franchise all around the world, where the connection between Al Qaeda in the Arabian Peninsula and Al Qaeda in, I don't know, the Maghreb was very tenuous to the point where it was almost a bunch of guys that just put a sticker on top and said, "Now we're Al Qaeda." How do you justify going against every single terrorist in the world um, when the connections between those terrorists and the war on terrorism was increasingly tenuous? And so this is where uh, um, a scholar, British former legal advisor for I think, the Ministry of Defense, um, and a scholar called Daniel Bethlehem proposed a set of principles to like sort of like update the law on self-defense for the rigors of the war on terror. And one of the main things that he did was propose a standard that was later called the unwilling or unable standard. Under this unwilling or unable standard, um, the burden of proof sort of changes from the attacker to the attacked. So the argument that he espoused was like the necessity component for use of force, whether the strike is necessary or not, needs to be understood based on what is the ability of the state of the target state to address the threats. And remember, we are talking about this like threat of this long-standing threat as imminent. Um, I so let me put it this way. Let's say there's a terrorist group in a country, and that country is trying to beat that group, but is not successful enough to make it go away. Under the unwilling or unable standard, the United States, or any state that subscribes to this view, could say that that inability makes it necessary for the United States to step in, because if it doesn't, then there will be an imminent threat to its own security, which is not exactly true, because not every group that the United States targets has the ability to launch an armed attack against the United States. Um, but that was the rationale. It's like if the United States deems the state unwilling or unable to target the threat, then the United States can intervene to solve the threat. So it is a very tricky concept because you are, first of all, you are saying that self defense applies to the non state actor, not necessarily the state involved, right? So for you to for you to be able to defend yourself, normally the entity attacking you, even if they do it through a proxy, has to be a state. So if a state sends a non-state armed group to attack you, they're still attacking you. What the United States says under the unwilling or unable standard is that it doesn't need to be the state doing it. If the state is unwilling or unable to tackle an independent non-state actor, uh, that can still be an imminent threat that justifies defending yourself against this, like, still not here armed attack, this perpetual armed attack that you can always defend yourself against, right? Um, this is not exactly how international law has traditionally been read. Um, we accept that non-state actors can trigger armed attacks when the armed attack of the non-state actor is attributable to another state, right? So a state is using a non-state actor. But when the non-state actor acts alone, we don't usually deal with that through international law. That's usually been dealt through like cooperation between states. And yes, of course, 9/11 sort of changed that. But the way that the UN Charter is designed, that cooperation needs to be translated into Security Council action. The Security Council needs to decide which terrorist groups are a threat to international peace and security and authorize, just like they authorized intervention in Kuwait, they need to authorize use of force against those groups. And then, of course, everyone says, but the Security Council doesn't work. So how is this a solution? And here's where it gets complicated because, like, sure, the Security Council doesn't work, but that's not the fault of the states that are being attacked under the unwilling or unable standard. A standard that does not give them any agency. They don't get to, write a form and say, I am actually being very willing to fight this terrorist group. It is the attacker state that decides when you're willing or you're not. It's a unilateral determination that you are unwilling or unable to tackle the threat, therefore I can invade you. So what's going on is it's no longer that the normal self-defense of an imminent attack. It's this: a terrorist group exists. I am at war with all terrorists. Therefore, all terrorist groups are an imminent threat. It's such a stretch of the applicable standard that it is very troubling, especially when it is unilaterally determined. So, of course, who is able to do that? Who is able to go to war against states in this way? States with big armies, states with like blue water capabilities, states that can go to war anywhere in the world, global north states. Who's usually unwilling or unable, deemed unwilling or unable? Global south states. So it is a regime, a rule that is proposed so that global north states can use force in the global south against states that they sort of know can't respond. They cannot afford a war with a global north country. Right? So Pakistan cannot really start shooting down U.S. planes because it keeps bombing civilian areas in Pakistan. So they sort of need to accept it. But this system would break the self-defense regime down if it were applicable between two quote unquote great powers, right? If the I don't know if Russia decided that the U.S. is unwilling or unable to tackle, right-wing militias and then strikes at the United States because it decided that it is unwilling or unable to deal with a terrorist threat, there's no way that the United States would say, "Oh yeah, okay, I'm so sorry. Like you can do that." It already didn't do it when England did, when the UK did it in the Caroline Standard. So why would it now, right? So the United States would respond, and Russia would respond, you are attacking me. I'm going to self defense against you. And so you would have Russia claiming self defense in US territory and the United States claiming self defense against Russia in US territory. So you would have two self defense claims clashing against each other that would make no sense. The unwilling or unable standard only works when one state is unable to respond. So it's an unfair standard. right? So it is not exactly the best rule because it is premised on the unequal power hierarchies that exist in our world. Um, so most global South states will see this as unfair, and this is why I think that my position with the unwilling or unable standard is yes, I know that under the current regime, it is the Security Council that should say this group is a threat to international peace and security. Let's pass a resolution so that we can go to war with them and solve the problem. And that's not going to happen. I acknowledge that. But why is it that we then respond to that with a, you know what we should do instead? We should do away with protections for weaker states, states that don't have big militaries, states in the global south, so that we can take matters, we being the great powers, quote unquote great powers, we can go to war and solve the problem ourselves. So let's water down global south protections against war because it is too difficult to reform global north privileges at the UN Security Council. That to me makes no sense. If the system is broken, then it should be fixed where it's broken. And it's broken at the Security Council. What we need is Security Council reform. Oh, but that's never going to happen. Yeah, but why should it happen then that states, global south states, accept that, oh, yeah, you know what? Whenever you feel that I am unwilling or unable to address a hypothetical threat against you, you can bomb me and kill my citizens. Why is that the easy way out? Why is that easier? Why is accepting that people must die easier than reforming the Security Council? So my position with this is yet another, just like humanitarian intervention, it's just another attempt at stretching the limits of self-defense, and in this case, at the expense of global South states. So it doesn't make a lot of sense to me. I think it's a very unfair system. It's a very imperial-minded system, very imperialistic in nature. Like its underlying logic is imperial. Um, and it doesn't work in any other context other than a neo-colonial context where one state is very powerful and the other state is not. It only works when one state cannot respond. So yes, there is a problem with non-state actors acting internationally, but no, I don't think we should solve it with like the unwilling or unable standard or more war. We should solve it through, you know, um, fixing the UN Security Council because making the system work. Why should why should we water down protections from war to defend privileges for the powerful? Right. So that is the state of use of self-defense right now. We have three valid causes of um, use of force: consent, Security Council, and self-defense, and several different attempts at stretching that definition to incorporate new ways of going to war: humanitarian intervention, preventive strikes, and the unwilling or unable standard. So we're basically in a tug of war between those states that want to maintain that narrow concept of use of force and states that want to expand it to other fronts, to non-state actors, to preventive war, to like and this is where we are at now. This is the state of play. Every single international lawyer that deals with use of force will have a position on this. There are many, there are several, they're very varied. I don't have the ultimate truth, so you can absolutely disagree with me, but this is what I think. I think that we should fix the problem at the cause, at the root, and the root is the Security Council. It is not lack of ability to bomb other states. Um, okay, High Altitude Cherenkov says, but my glib remark does raise the more precise question, just what restricts the creativity of lawyers trying to come up with arguments serving their clients? When does a lawyer's partisan argument cross out to the realm of a proper legal argument? I was actually talking to a PhD student at King's recently that was actually making this exact point in his PhD thesis. So when it's published, I will, you know, put it on social media so that everyone can read it and he can answer your question because it is a difficult question. At what point is legal creativity BS, and at what point is the expression of the evolution of the law? Because we all accept, well, most of us accept that the law is not static, it is alive. So it is an excellent question. I will not attempt to answer it right now because it would take me an entire PhD. So yeah, um, but it is an excellent question. Iconoclast says, is there any tool or body at the UN level and at the hands of the GA to investigate legality or warfare in such interventions? Well, the UK had trials on this, like actual criminal trials on this. Um, Theoretically, the plan was to have the International Criminal Court decide on crimes of aggression, but the definition of aggression is so narrow, and the US is not even a party, that is very difficult. So in the case of the US, it's actually quite hard to um, to investigate and prosecute this. It should have been done at the domestic level by the United States itself, but the United States, especially in the drone war, there's a famous case, Anwar al-Awlaki. I'll write it in the chat. Anwar al-Awlaki. Uh, I think it's US v Anwar al-Awlaki. I'm writing in the chat right now. Oh, so hold on. I'm writing in the chat here. Anwar al-Awlaki. So in this case, the United States droned a um he was a propagandist basically. So he was not someone that was ordinarily a target under international law. And the um they tried to prosecute this in courts. They tried to put the people behind this strike behind bars. But U.S. courts decided that this was instead a um, political act that was unjusticiable, so you could not sue for it. So meaning that you can never really complain if the U.S. drones you, which is a big problem. There are other non-binding mechanisms like the special procedures at the UN. You can go to like the Human Rights Committee and or in the case of like the United States, you can go to the Inter-American Commission. But the problem is that those decisions, while authoritative, are not binding. So something like the ICJ advisory opinions. So um, different states have different positions on how binding they are, but I mean that's something that their domestic laws need to evaluate, and the United States will not hold them as binding. So it's tricky. It's very tricky to get the U.S. To comply with international law. Boulevard of Dreams says, perhaps to further elaborate on the previous question on Hamas' right of self-defense, what about Israel's right of self-defense? Yeah, okay. Let's get on to that, okay? Um, Wait, before that, Iconoclast says, has there been any real debate about reforming the Security Council's privileges? There are ongoing efforts. There are plans to incorporate other states into the Security Council, but I mean that's a broader discussion and we're not even sure if that's going to happen. So let's get into the big topic. Okay, let's talk about self-defense in the context of Israel-Palestine. Okay, so we have distinguished self-defense from um, reprisals, meaning that exchanging missiles is not self-defense, right? Exchanging missiles is just exchanging reprisals. If you shoot missiles at me, they fall, and then you shoot missiles against me, and they fall, and then we just exchange. Missile warfare is not self-defense. It's just a series of unlawful uses of force on each other. Okay. I also need to distinguish this from another principle called the protection of nationals principle. Every state has a right to protect their nationals. Um, it has a duty to protect nationals in in their own borders, and I would argue also people under their jurisdiction. So I'm not a British national, but like I think the UK cannot just crime against humanity me, you know. But specifically nationals can be protected even when they are abroad. The thing is, they can be protected through diplomatic means. So there's a thing called diplomatic protection. And so if you are ever traveling on holiday or something and you're arrested, for example, you have a right to consular protection. They have to read you just like cops need to read you your Miranda rights in the United States. They need to read you your consular rights if you are a foreigner abroad that is detained. If they don't, then your detention might be unlawful. So, and if a state harms you, you can go to your own state and say, "Can you assume my protection diplomatically?" So this is a key thing. Okay, protection of nationals doesn't usually trigger self-defense because it's not an armed attack. So you're not really protecting yourself against an armed attack. So there are famous examples of citizens being at risk abroad and states doing things to rescue them, using force without the consent of the host government, and the international community reacting sort of like this is not legal. Even if states will probably say, I will, if it's illegal, then I'll violate international law. But generally speaking, protection of nationals does not trigger the right to self-defense unilaterally without anything else, without Security Council authorization, without consent. Um, so, do the Druze have the right to be protected by Israel, given that Israel is the occupier? Yes, I will get to that right now. So, thank you, Edward. So, let's distinguish self-defense, which we have already understood as defending yourself against an armed attack, from reprisals, from protection of nationals. Three different things. So, how do these apply? The first thing we need to understand is that in the context of October 7th, absolutely 100% Israel had every right to protect its population from the attack in October 7th. It had to protect its population through compliance of international human rights law, of course. It or international humanitarian law. It could not protect it, say, by like nuking Gaza or anything like that. But sending its troops and using force against Hamas militants or using the Iron Dome to stop missiles from landing, that would be permitted force because it was a force done under the idea of protecting your own nationals. No one can prevent you from protecting your nationals. And the problem is that often when people talk about self defense, they say that is self defense. Defending against October 7th was self defense. And it wasn't for several reasons. Because Hamas is not a state. And so, as we've discussed, whether non state actors can actually carry armed attacks is contentious. I would argue that they can't. So that can't. So that's not what how it would work. The defense, Israel's defense against October 7th would not have been self-defense; would have been protection of nationals. But then there's another problem, um, particularly with Israel's response to let's assume for sake of argument Hamas's armed attack, quote unquote. In that the strike needs to be proportional and necessary, meaning that it needs to address the specific use of force. It needs to stop the threat. Of course, if you believe that the mere existence of Hamas is an existential threat, then the idea is the proportional response is to go in and destroy everything until Hamas is destroyed. But if you don't believe, like we have established that I don't believe that the mere presence of a terrorist group is not enough to trigger like this like existential self-defense that a constant armed attack that you can defend yourself against, then the proportionate response is not to flatten everything down. Of course, it's not. So even in that scenario, it starts looking more reprisally, more like a reprisal than as self-defense. But the mother lode of the argument is you can only act in self-defense against an armed attack, right? Israel is now, as confirmed by the International Court of Justice, occupying Gaza. It is, or at least has the obligations, several of the obligations of an occupier in Gaza. So, so if it is the occupier, it means that it is deploying force in another territory. In my view, as we've discussed before, in a state, in the state of Palestine, in the Gaza area of the state of Palestine, or in a self determination unit of Palestine, if you don't believe that Palestine is a state. But that force can only be legal if it is self-defense, right? That occupation can only be legal if it is in self-defense. So you have one of two scenarios. Either the occupation is legal because it was an act of self-defense against an imminent Egyptian attack, or it was an illegal use of force, the occupation, because it was a preventive strike against Egypt and Syria, right? I believe the second one, but like those are the two possible scenarios. And Israel goes in arguing self-defense into Palestine, the West Bank and Gaza. Once it occupies the West Bank and Gaza, um, it needs to maintain that argument of self-defense. It cannot just stay indefinitely in, um, you know, in Gaza and the West Bank. It cannot be an occupier forever because for the occupation, for the use of force to be legal, it needs to be in self-defense. What is the argument of self-defense for the occupation and the blockade of Gaza? And so the International Court of Justice stated, for example, that the need to protect settlements in the West Bank is not enough to trigger self-defense to occupy the West Bank. Um, and similarly in Gaza, the presence of um, the if the initial strike was illegal, then the occupation of Gaza is not legal. But assuming that it is, okay, let's assume that the occupation is legal. Once you are deploying that occupation, you are no longer acting in a territory that you don't have control over. You're no longer crossing borders to attack someone. If you are not crossing a border, if you are the occupier, it's the other way around. You become responsible for the people that live in that land that you are occupying because you're the occupier. Right? So if you are responsible for those people, you cannot defend yourself against those people because you need to take care of them. You can rather restore order and law enforcement to that area. But you are acting as if you were the state. You are acting as if you were their sovereign, right? As if you were an administrator of the land. So you're not there to defend yourself. That's why you're there already. That's the argument for the occupation itself. Once you've established the occupation, you become the government. And as the government, you need to protect, you need to restore order. You are working for the occupied population, for their benefit. So how can you claim that that is self-defense if you are occupying land? Right? So that is the tricky part. The standard changes once you occupy territory. It changes from self-defense to restoring order. So it would not Israel would when people say Israel does not have a right to self-defense in Gaza, they mean that for them to have a right to self-defense, then they would have needed to not be occupying Gaza in the first place. And the ICJ has already established that it still retains at least some occupation obligations. So self-defense would be triggered if Gaza was a separate entity from Israel, not a territory that is occupied by Israel. Once it's occupied, then the paradigm shifts and it's no longer self-defense because because theoretically you are already deploying self-defense to occupy. So how can you say that the resistance to your self-defense allows you to self-defend? Right? So if someone steals something from the army in Gaza or the West Bank, Israel cannot say that they are defending against that stealing because they are the ones already deploying self-defense. The paradigm shifts to either controlling order in the occupied territory or dealing with the right of resistance, but not self-defense. So I guess what I mean is no one is when people say Israel does not have a right to self-defense in Gaza, they we don't mean to say that it doesn't have a right to protect its population in Israel from attacks by Hamas, and it doesn't mean that it cannot do anything in Gaza. It just means that what it can do should be as the occupier for the benefit of the occupied population. Right? So self-defense is the wrong paradigm, is what we're trying to say. Is that clear? Does that make sense? Because I know it's a tricky thing to argue or to explain at least. So to the question, do the Druze have the right to be protected by Israel, given that Israel is the occupier? I would say yes. Like the Druze absolutely have to be protected from a strike from Hezbollah that's coming on them. Israel does not only have the right, it has the duty to activate the Iron Dome and prevent those people from being killed. Absolutely 100%. Now the question is, does Israel have a right of reprisal against that strike? No. The attack finished. Unless the launching platform is still there, um, there would not be a right to reciprocal reprisals. Right. so, so Israel has a right to protect the people it occupies. It does not have the right to claim self-defense against people that are under its occupation, because the occupation needs to be self-defense to begin with. So it kind of like breaks the paradigm. Does that make sense to you guys? Have I done a good job explaining this to you? Okay. How does the Hannibal Directive mesh with the responsibility to protect nationals? Oh, I think the Hannibal Directive is the idea of that if an Israeli national is captured and kidnapped, the response by the Israeli government is it's better that they die than they be kidnapped. I think that's illegal under human rights law. That cannot be what the state decides. Like because it is an unnecessary use of force. There are other ways. It's not a last resort. It's not the you have other means, including negotiating, to bring them back alive. So I think the Hannibal Directive is just a crime against humanity. Um, so Hamas under international law can attack Israel. Um, okay, so we're getting into the right of resistance. So once an occupation has been established on a territory, the population in that territory, whatever nationality, has a right to resist that occupation. There's no duty of loyalty from the occupied population to the occupier state. They don't have to be loyal. They can resist. Ukrainians can resist Russian occupation. Palestinians can resist Israeli occupation. The discussion at the heart of this right of resistance thing is, what does it mean to resist? And there's this like slogan that you've probably seen in like the marches and stuff like that. By any means necessary. It's a Malcolm X quote. That might be a slogan, but that is not international law. The right of resistance is not by through any means necessary. The legal formulation for the right of resistance is through any available means, because we accept that the right to armed struggle is not unlimited. It is limited by the same rules of warfare. You cannot torture. You cannot commit war crimes. You cannot commit crimes against humanity. You cannot commit genocide in resistance to occupation. You can tell me that you have different ideas on the politics of this, but in the realm of international law, that's how it works. We do not accept that peremptory norms, use Kogan's norms, can be violated because you're resisting, right? So while Palestinians have a right to resist, and they can do so in organized fashion, they do not have the right to do it through war crimes and crimes against humanity. So I would argue to your specific question, um, I would say um, Palestinians have a right to resist Israeli occupation, provided that they do so through all their available means. So there's a big disagreement among people that study right of resistance about whether what Hamas did on October 7th was counted as either illegal resistance because it was resistance through the commission of crimes against humanity. Or I mean specifically those acts, right? Like specifically the illegal acts counted as illegal resistance, or because they were illegal, then you should not call it resistance. And I've had many difficult conversations with friends about this. It's not really settled, but that's the discussion. Is it that it is? It's not whether it's like uh, good or bad. It's that committing a war crime is bad. You cannot you cannot argue around that. We don't want war crimes in international law. And so what we're discussing is it illegal resistance because it was a war crime, because it targeted civilians, or because it was illegal, then it wasn't actual resistance. That's the discussion. But on the more general argument that you're making, do Palestinians have a right to resist? Yes, they do. Does that resist? Can that resistance take the form of military action? Yes, it can be armed struggle. Very clearly, that's very clear in international law. The rest of the discussion is more nuanced, of course. Um, uh, okay. Vicious Chicken of Bristol. Is it established that Israel occupies Gaza? I think Israel doesn't think so. Israel doesn't think so, but like, so let me put it this way: when you have occupied territory and you move your troops out of that occupied territory, you build a wall around the territory that you occupy. You put guards on those territories, and you control access to every access point of that territory, including the Egyptian side, because the Egyptians have to coordinate with the Israelis what comes in. That's part of the normalization between Egypt and Israel. And then you're the one that sends water, you're the one that sends electricity, you control everything that goes on in there. Have you actually disengaged from the occupation? Or have you done this like derelict of your obligations as an occupier, but maintained the people there trapped? If the people in there cannot leave, did you really stop the occupation? No, you didn't. You're just breaching your obligations as the occupier. That's what I believe, at least. If we assume the right of people to resist occupation, does Israel of 1948 borders count as a legitimate territory, obviously within the confines of the law? Okay, that is a huge question, and we are already 1 hour and 32 minutes in, so I'm gonna need to stop soon because it's getting late for dinner. Um, so I'll recommend that you watch the other episode on the Palestinian statehood so that you can, you know, I answered that in that video. Um, Jens is talking about the German case. Yeah, there's a famous German case where said that in a 9/11 scenario, the German state cannot shoot down a plane, basically. Um, thank you for the link, Jens. Okay, so um, that's self-defense in the context of Israel-Palestine. That's where it comes. That's why it is so tricky because Israel is already deploying what should be self-defense in the form of occupation. So once you're already deploying self-defense, you are no longer debating whether you will cross a border to apply to attack another country without its consent. You already did. And when you do, you get obligations to protect that population. So when people say, I think this is the most important thing that I can say, when people say Israel does not have a right to self-defense, they are not saying that it doesn't have a right to defend itself from attacks by Hamas or Hezbollah. They are simply saying that you cannot defend yourself against territory you control. You can only defend yourself against armed attacks that come from outside. Right? If you are occupied, if you have jurisdiction over that area because you're occupying it, then that those attacks are actually resistance to your deployment of force. Either you are being the aggressor and therefore Palestinians are acting in self-defense, or you are acting in self-defense but they are still resisting you. In no scenario would you be able to claim that you are doing self-defense on top of your self-defense. Right? So either you are the aggressor and they have a right to self-defense to your illegal occupation, or you are acting in self-defense and and they are just acting in under their right of resistance to an occupation. But that's not self-defense. So I just want you to understand that this is a technical discussion. When we say there's no right to self-defense, we don't mean that Israel is defenseless. Those are two different claims. I just wanted to leave that clear. Um, hopefully that is clear. Okay, guys, I'm gonna need to go because it's very late and dinner time. So stay tuned for Wednesday so that we can have a now officially a PS5 playthrough of The Last of Us and talk about human rights and like self-defense in the context of the game. Okay. Um, Thank you so much for tuning in. And sorry about the delay today. Hopefully this was useful for you guys. If you still have any more questions or you would like me to cover other topics, let me know on on Twitter or here in the chat, and I'll happily cover them. Thank you so much. This was a shorter chat than usual, but it is getting late, so I do need to go. Um, Thank you so much for coming here. Tell your friends about this. We're actually very close to becoming affiliates for Twitch, which is amazing. Um, Let me please follow the channel and everything. And I'll see you guys on Wednesday. Okay, bye.